her hands and legs so as to visit a nearby hillock. Pusta. Daughter of the complainant blindly believed the instructions of the first accused and went near the canal for washing her hands and legs. And at that juncture, it is the first accused who pushed the daughter of the complainant into the canal and then came back as if he doesn't know, he did not know anything about the missing of the daughter of the complainant. First, this information was received by the police after apprehending the first accused. First, since the entire incident is based on circumstantial evidence and dead body was traced at the instance of the voluntary statement of the first accused, police not only registered the case against the first accused and taking note of the complaint governments, registered the case against the parents and the brother-in-law. Innobba brother-in-law na fourth accused.
A1 uncle.
And the uncle of the first accused. First. After thorough investigation, police filed the charge sheet for the aforesaid offences against all the four. First, next para. Presence of the accused persons were secured before the court, and when the charges were to be framed, present petitioners and others filed charge sheet, filed application under section 227 CRPC. First, our application.
They are dropped.
All the four bada. After thorough investigation, based on the material collected by the investigation agency, investigation officer thought it fit to file the charge sheet only against the present petitioner and his son, while dropping the case against the mother of the first accused and uncle of the first accused. First, next para. Amal present so and so. First, present petitioner filed an application under section 227 CRPC to discharge him from the case. First, state opposed the said application by filing detailed written objections. First, next para. Learned session judge heard the parties in detail on the application and by order dated 31st of October 2023, dismissed the request made by the present petitioner. First, being aggrieved by the same, accused number 2 is before this court in this revision. Next para. Shri Gaurav, learned counsel for the revision petitioner, reiterating the grounds urging the revision petition, vehemently contended that there is no material on record to show that there was a physical and mental torture imparted to the deceased by the present petitioner, and therefore he cannot be held responsible for the aforesaid offences. First, he also pointed out that the material collected by the investigation agency itself shows that it is the first accused who nurtured the idea of taking away the life of deceased with an intention to remarry some other person, and therefore attributing the intentions to the present petitioner is totally unwarranted and sought for allowing the revision. First, he also pointed out that the principles of law enunciated in the judgment of Vijayan, Amit Kapoor, Dinesh Tiwari, State of Tamil Nadu versus Suresh Rajan, State of Karnataka versus Muniswamy, Sanghi Brothers versus Sanjay Chowdhury, Shivram Shetty versus Delhi Police.
I've placed a memo with citations. Authorities.
One day has not been properly appreciated by the learned trial magistrate, learned trial judge, while dismissing the application filed by the petitioner. First, in support of his contentions, he has also placed on record following judgments, wherein it has been held as under adikella paint tax. Per contra, ಇದನ್ನ ತಗೊಂಡು ಅವ್ರಿಗೆ ಯಾವ್ದು ಬೇಕು ರೆಲೆವೆಂಟ್ ಪೋರ್ಷನ್ ಹಾಕ್ಸ್ಕೊಂಬಿಡು. Per contra, learned counsel for the learned HCGP supports the impugned order. First, next para. In the light of the rival first, learned HCGP also emphasizes ಇದೆ ಬಿಚ್ಚಿದೆ ಇಷ್ಟೇ ತಕೊಂಡ್ರೆ ಇದನ್ನ ತಕೊಂಡು ತಕ್ಕೋ. Also emphasizes that the material available on record collected by the prosecution alone is to be looked into while framing the charge and not the defense that is to be taken by the accused. First, he also points out that there is a presumption available to the prosecution under section 304B, under section 113A and 113B in respect of offense under section 304B, and therefore, the material evidence available on record is sufficient enough to hold that accused number 2 is to stand for trial for the aforesaid offences and sought for dismissal of the revision petition. First, he further emphasized that the investigation is impartial and it is not perfunctory in nature, in as much as even though allegations were found against the mother of the first accused and uncle of the first accused, mother and uncle of the first accused, the investigation officer, after thorough investigation and collection of material available on record, thought it fit that no case is made out against the mother and uncle of the accused, first accused, and dropped them while filing the charge sheet. Dropped them while filing the charge sheet. First, this conduct on the part of the investigation officer is to be appreciated, that he did not find any material against the mother and uncle of the accused number 1, but has collected the information material so as to proceed against the father of the accused number 1, who is the present petitioner, and therefore, sought for dismissal of the revision petition. First, in view of the rival contention of the parties, this court bestowed its best attention to the material on record meticulously. First, next para. On such perusal of the material on record, it is seen that there is a specific allegation against the present petitioner in the charge sheet materials. First, especially with regard to the demand of the dowry amount and receipt of the dowry amount by the present petitioner is evidenced by the material documents collected by the petitioner. First, in para number 11, 12 and 13, para number 11 to 14, the learned trial judge has discussed in detail the material available on record so as to proceed against the second accused, who is the revision petitioner. The same is called out here under for ready reference. First, thus, the material available on record is sufficient enough to make out a triable case as against the accused number 2. First, further, the principles of law enunciated in the decisions relied upon by the learned counsel for the revision petitioner was also discussed by the learned trial judge in detail in the impugned order. First, next para. It is also found that it is also settled principles of law that it is the material placed by the prosecution alone to be looked into at the time of framing the charge and not the defense. First, in this regard, gainfully, this court places reliance on the judgment of the Honorable Apex Court in the case of Devendra Padi versus State of Orissa, wherein it has been held as under para number 25 to 20 to 27. Next para. Learned counsel for the revision petitioner to substantiate his contentions, while referring to the decisions rendered relied upon by him referred to supra, has drawn the attention of this court to the judgment of Khakas Khan Kausar. First, their lordships of the Honorable Supreme Court in the said case held that if the parents of the victim have not shared the common roof, normally such person should not be proceeded for the criminal prosecution where harassment is complained of either by the wife or their parents. First, in the case on hand, admittedly, accused number 1 and 2 shared the common roof. Therefore, the principles of law in Khakas Khan would not be applicable to the case on hand. ಮೊದಲನೇದು ಮುಗೀತಲ್ಲ, ನಾನೇ ಬೇಕಾದಷ್ಟು ಕಾಸ್ಟ್ ಮಾಡಿದ್ದೀನಿ ಕಾಕಸ್ ಖಾನ್ ಹಾಕಿ. ಅಲ್ಲಿ ಅವರೆಲ್ಲೋ ಬೇರೆ ಇರಬೇಕು, ನೀವೆಲ್ಲ ಬೇರೆ ಇರಬೇಕು.
ಪ್ರಾಕ್ಸಿಮಿಟಿ ಆಫ್ ಟೈಮ್,
ಪ್ರಾಕ್ಸಿಮಿಟಿ ನೀವ್ ಹೇಳ್ಬೇಕಲ್ಲ. ಫೋನ್ ಮಾಡಿ ಕೇಳಿದ್ರೆ ಪ್ರಾಕ್ಸಿಮಿಟಿಗೆ ನನ್ನ ಮಗಳು ಮಿಸ್ಸಿಂಗು ಅಂತ, ನನ್ನ ಮಗನೇ ಇದು ವಿಷ ಕುಡ್ದನ್ ಬಂದು ನೋಡು ಅಂತ ಹೇಳ್ತೀರಿ ನೀವು. ಹಂಗ ನಿಮ್ಮ ಮಗಳೇ ಹೋಗಿದ್ರೆ ಹಂಗೆ ಹೇಳ್ತಿದ್ರ? ತಮ್ಮ ಮಗಳೇ ಮಿಸ್ಸಿಂಗ್ ಇದ್ರೆ ಹಂಗೆ ಹೇಳ್ತೀರಾ ವಕೀಲ್ರೆ? ಫರ್ಗೆಟ್ ಸಿಂಪತಿ, ಅಟ್ಲೀಸ್ಟ್ ಎಂಪತಿ ಬೇಡವಾ? ಎಂಪತಿ ಬೇಡವಾ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಫರ್ಗೆಟ್ ಸಿಂಪತಿ. ಇನ್ನೊಬ್ಬರ ಮನೆ ಮಗಳು ಹೋಗ್ಲಿ, ಇನ್ನೊಬ್ಬರ ಮನೆ ಮಗಳಾದ್ರೆ ಇವ್ರಿಗೇನು ಟೋಟ್ಲಿ ಅನ್ಕನೆಕ್ಟೆಡಾ? ಇವ್ರ ಮನೆ ಬಳಬೇಕಾಗಿರೋ ಸೊಸೆ ಅವಳ ತಪ್ಪಿಸ್ಕೊಂಡಿದ್ದಾಳೆ ಅಂದ್ರೆ ನ್ಯಾಚುರಲ್ ರಿಯಾಕ್ಷನ್ ಏನಿರ್ಬೇಕು? ಬರಿತೀನಿ ಅದಲ್ಲ. ಅದಕ್ಕೆ ನಾನು ನಿಮ್ಗೆ ಕಾಶನ್ ಮಾಡಿದೆ, ಬೇಡ ಅವೆಲ್ಲ ಅಂತ. ನೀವು ಕೇಳಿಲ್ಲ. In case of Rajiv Kumar, their lordships were of the opinion that the medical report having regard to the nature of injuries sustained by the victim, where the victim died on account of the burn injuries, took into consideration about the role of the accused and then decided that he had no proximity with the time or the incident, and therefore were of the opinion that such person should not be made to stand trial. Facts of the case in the present case are altogether different. In fact, according to the prosecution, based on the voluntary statement given by the accused, the important circumstance, namely the place of dead body being found is recovered by the investigation agency. Ali statement of the voluntary statement of accused number 1, important circumstance in the prosecution case, namely the detection of the crime and place of dead body being found is recovered by the police. Posta next para. The incident admittedly has taken place on 16th November 2021, and when there was a call made by the complainant to the present petitioner on 16th evening and again on 17th morning, there was a passive response from the present petitioner. First, deceased is none other than the daughter-in-law of the second accused, and daughter-in-law of the second accused. First, if not sympathy, at least empathy should have been there with the conduct of the present petitioner in searching the dead body, in searching the missing daughter-in-law. First, the conduct shows that he did not care to find out what has happened to his own daughter-in-law. First, further, the circumstance that the first accused said to have committed the attempted to commit suicide is intimated by the second accused to the complainant in a very casual manner. When there was a call made by the complainant to lodge the complaint about the missing complaint about his daughter, second accused, as a normal prudent person, should have accompanied the complainant in lodging the complaint, or for that matter, first accused being the husband of the deceased should have accompanied. If they are so innocent as is sought to be portrayed, full stop. But the second accused says that his son, that is the first accused, has tried to commit suicide, full stop. Even that answer was in a very casual manner, full stop. No details are forthcoming as to whether the first accused was taken to the hospital, full stop. No other material is also forthcoming from the application of the second petitioner as to what is the normal prudent person would behave if his son has tried to commit the suicide. First, in other words, comma, as could be seen from the material on record, comma, probably the first accused must have revealed what happened on 16 to the second accused, and therefore they were fearing to visit the police station. Anyway, this